Hi everyone, my name is Joseph, and today's success story is about this Chinese family and how the mother was able to secure her green card. Again, after the customs officer took it away and gave her a notice of intent to appear and go to immigration court. This happened in 2023. She flew to the US. Her husband was a US citizen. Her children are US citizen, but she hasn't been here for like 3-4 years in 2023. Mind you, COVID 2020, 2021, 2022, right? So she thought she was safe. She thought she had US citizen spouse and children. She thought that they're going to school, they're paying taxes, they have company. She thought um, COVID was a legitimate reason, but none of that was able to pass the smell test with CBP officer. They confiscated the green card and gave her a notice of intent to appear. Didn't even go through deferred inspection and said, you have a trial. The trial was set in 2024, right? Like September 2024. And after that, obviously, it was extremely concerning for her. She was stuck here in the US. Normally, she travels in and out, in and out, and out. I mean, that's the main reason why the CBP officer confiscated the green card and didn't even give her a chance to go deferred inspection, because her past 10-year travel record just doesn't look like she lives here. So now she's essentially forced to stay, or she could file the 407 and abandon her green card, but she didn't want to do that. So she wanted to go through this trial. So she stayed in the United States. Her US citizen spouse graduated from a top university here in California, was with her. Her children were young with her. So they're staying here. And it took a whole year before the immigration court assigned a district attorney to this case. And at that time, our team, before the trial, wrote this long brief explaining why she did not abandon her residency, why she has a US citizen spouse, why it will be a waste of government resources as well as her resources to go through the entire trial just so that the husband could turn around and file a new case for her. So that was the strategy. Now, you might be asking, why didn't she just file a new case right in the beginning? Why wait a whole year? Because the family just didn't believe that that's what's required, right? They were hoping that the government will see that and say, okay, we'll give their green card back. And in truth, prior to COVID, we did a lot of that. Prior to COVID, somebody leaves the US for 6 months, a year, green card gets confiscated, goes to deferred inspection. We go with the client to deferred inspection. We plead the case, the government gives the green card back. They start the NTA trial. Sometimes in the past, it wasn't a whole year, it was like 3 months. We go to see the DA, we convince them, they give the green card back. They could not fathom that this incident of a spouse of a US citizen, mother of 2 US citizen children, a scholar in her own right, wealthy taxpayer in the United States, would be stuck here for over a year without even any attorney overseeing their case to even talk to discuss, right? Because it went right through deferred inspection to the immigration courts. And then they did not believe that they have to go through the whole immigration system again. So that's why they didn't do it. But the day before trial, we wrote this long explanation, sent it to the DA. The DA response says, okay, file the case, show me the proof of receipt, and I will admin close this case. But prove it. And of course, right, within the same day, we get that email, file the I-130, and then within, I think 3 weeks, in late 2024, we gave the receipt, and then within a week, close the case. And then, bam, I'm on paternity leave. Now, what's so special about this case being closed? Well, it means there's no trial and her green card is not taken away. She still has her lawful permanent resident status. So again, in 2023, when she entered the United States, she came in with a green card. Even though it's confiscated, she still entered as a lawful permanent resident. She still has all the rights and privileges of a lawful permanent resident. If anything should have happened to her during the course of this past 1, 2, 3 years, the inheritance, the estate tax, the IRS, everything, she's a lawful permanent resident. Now that the case has been closed, there's only two ways to lose your lawful permanent resident status. There's three ways. One, you forfeit it, sign the 407, mail it to USCIS, they receive it, boom, it's canceled, it's irrevocable. Second, an immigration judge determines you've abandoned it, you're inadmissible, and cancels it. Or three, USCIS sends you a notice of intent to revoke your lawful permanent resident status, and then you could go through trial for it, right? So generally, there's only three ways to lose your lawful permanent resident status. She didn't abandon it. The case is closed, so there's no immigration court, and USCIS didn't do anything. So she still has her lawful permanent resident status. But at any given moment, the government can reopen this case, rule on the merits, and revoke her lawful permanent residency. So essentially, they're forcing the US citizen and the beneficiary, the mother, to go through the entire I-130 485 process all over again, just so that they can get the green card again. And by default, the government forced them to live in the United States for about 3 years already, right? From 2023 till now, it's, you know, like, well, almost a full 2 years without even going through the 485 process, right? So now technically, can the husband just end it with the I-130? Sure, but are they going to feel safe doing it? Is the wife going to feel safe to never leave the country ever again? No, she still needs to travel. But the next time she travels, she comes back with the green card. It's going to be quite terrible experience at the CBP, the frightening situation, right? So they definitely want to go through a new green card application process to get it and then clear their name and then apply for a reentry permit next time. But that's a crazy case, right? This happened in 2023, all the way up till actually this week. We still help people who left the US for over 8 years and come back. But this was in 2023. It might have been a bad officer, might have been a bad record, might have been some bad replies, but the wife just wasn't ready to see the customs officer. And so, again, going back to the news update in the beginning of this segment, if you don't prepare well and you answer incorrectly and the officer feels like you're lying, they could totally take your green card, right? Do not bank on the fact that, oh, I have my US citizen children, I have my US citizen spouse. Somehow they make you immune to comply with the rules and regulations of the United States of America, right? As a lawful permanent resident, you are supposed to live and work here in the United States. If you're out for a significant amount of time, you should have applied for a reentry permit. You should have a good explanation. But if you don't, it doesn't matter if you have US citizen spouse and children or anything else, or you pay taxes. The CBP officers, they could still confiscate your green card, right? So that was how we dealt with this situation. We were able to get the government to admin close the case, but the client was still stuck here for 2+ years. That was not their life plan. It is extremely unfortunate, but at least the green card was preserved. Now, of course, they could have an option. Fine, I abandon it, I leave, my husband applies for me again, and I go through the consular process. But then they had to calculate, well, do I want to do that? What if the consulate doesn't approve my green card and now I'm really stuck abroad? So weighing between, okay, living here in the United States, suffering through the 2-3 years and changing all the plans, but able to get the green card again, versus going abroad and then never coming back into the United States. Between those two options, they chose to stay, they chose to fight, and we're glad we're able to resolve that problem for them. But again, right, cure is never as good as prevention. So if you can prepare your case well, demonstrate that the US is your home, that being abroad was temporary in nature, you have a much better chance in succeeding. And now more than ever, it is important to prepare well. Okay, and that is the success story for today. Thank you for watching. Take care. Bye-bye. Okay, for all the live audience, that was the filming of the success story. Okay, we're going to cut that up and post it in a bit. And now we can answer some more questions. How much time do we have left?
It's 12:45.
Okay, 15 minutes of questions.
Okay. We filed I-751 2 weeks late on accident. Wrote affidavit. Could they deny it based on this?
Not likely. 2 weeks is fine. We've seen late filings, 2 years, 3 years, 5 years. We had a late 751 waiver that was over 10 years. Now, obviously, under immigration law, late filing for a joint petition, you need to give an excuse. A late filing, if you're self petitioning, there's no time limit. Just some trivia for you. But a couple weeks is not a big issue at all.
Can those who are in the list of travel ban
Yeah,
yellow list travel with a green card?
I do not recommend it. I do not recommend anybody who's on any travel bans to travel
Do you know why F4 category is slow?
because it is not a priority. Why are some categories super slow and some categories much faster? Why are some categories don't have any wait time? They could just immediately apply. That's how the immigration law is built. The Congress determines in all of its wisdom and governance that F4 should be slow.
Can I AOS? I have legal entry and my son will be 21 this year.
Can you adjust your status in the United States? Your child is about to turn 21, they are a US citizen, can they petition for you? The answer is legally yes, but what are the obstacles you're going to face at the interview? Here is the thing. The US officer, government, will want to see whether or not this was premeditated and if you deceived and you lied to an immigration officer, right? So you want to document well, you were just a tourist coming here and you didn't plan on adjusting a status. You did not plan on an AOS or a COS. You purely wanted to go to Disneyland or something. And then something major happened and you couldn't. And you change your mind and suddenly you realize your child is 21 and they want you to stay and you want to stay and you filed. You want to prove that you did not lie to an officer because that would be a crime.
I have no SSN and my EAD has not been approved yet. How but have been scheduled interview?
Your work permit 765 had not been approved yet. You have no social security number and you already got an interview. Is that what you're asking?
Yeah,
Okay, and you're asking why?
yeah.
Um, if you're optimistic, it might mean that your case is going super smoothly and they'd rather prove your green card first without spending the time or research to approve your travel permit or your work permit, right? Just directly jump to approving your green card because then they'll save everybody time and money. They have been doing this for over 3-4 years, right? And so, last year, the year before that, we've seen tons of cases. Even though you pay for the green card, you pay for the work permit, you pay for the reentry permit, but they just toss all those other applications aside and just directly expedite and approve your green card. We have seen that done in hundreds of thousands of times across this country over the past few years. So if you're optimistic, you're like, wonderful, I'm like them. If you're pessimistic, that might mean they think your case is really bad. They do not want to approve your work permit. They do not want to approve your travel permit. They want to deny your case and deport you as soon as possible. So, heaven or hell?
Okay. How likely is a court to grant preliminary injunction after a TRO?
Is it if you are on the F1 student visa and you are part of this great body of people that have been violated by the US government by canceling your F1 visa without notice, without due process, in my opinion, if you had a good argument and you are in a kinder immigration district, I think there is a high chance your preliminary injunction would be approved. I have strong faith that it will be. What happens after the preliminary injunction is up for grabs. There's two theories behind what's going to happen. We don't have to get that now. I made videos about that earlier. But if you're just talking about the preliminary injunction, I personally feel immigration judges all across this country respect and honor due process, honor and respect our legal system, and they will afford you the privilege of approving your preliminary injunction.
Is the court reopening withholding cases for I-485 now? How long does it take?
So I think that was one of the first questions, right? It depends on your case. There was a period where they weren't opening it at all, and then there was a period where they were opening everything. I got that reversed. They were in a period to open everything, and then they went to a period of not opening anything. We're in a period of half-half, right? And so if you have a good case, you can argue they should be reopened. They could. Yeah, it takes a couple months.
Okay. Should I file for citizenship now? I have been a green card holder since 1977.
You should have filed for citizenship long time ago, sir or ma'am.
Apply for my brother over 12 years ago and still waiting. What should I do?
Keep on waiting.
As my case is stoking in USCIS, how can you help to get them approved the green card?
If your case has been pending for a long time with USCIS, if it's beyond processing time, you can try to contact them through the InfoPass system. You can do customer service with Emma online. You can write to a congressman to check on the case. That's only if it's beyond processing time. If it's not beyond processing and you have an urgent need, you can also do the same methods. But it might not lead to anything, but still, those are the methods that are free that you can do. It is your right to be able to do it, right? They answer to you. You are the people paying their salaries. So, InfoPass, calling, make an appointment, and then go and talk to an officer. Emma is online chat, talk to the customer service. Call them, talk to a customer service, tier 2 or tier 3 officer. Contact your senator. Senator writes letter to USCIS to get an update.
Okay. My VAWA was approved last year. Today I got a letter requesting medicals. What's next after this?
Your VAWA was approved and you got a letter requesting medical. So it sounds like you are in the adjustment of status phase. And so during the adjustment status phase, there's a lot of things that you need to comply with, right? So go back to the I-485 form and look at all the requirements. Medical is one thing, but there's financials, there's all the address updates, there's criminal records, there's tax returns, there's finances, there's everything that you need to do clearly. So make sure you go through all of that. We had a client that did 7 requests for evidence until they were about to just give up and cry and pull their hair out. And then they found us, and then we did everything for them within like 2 weeks, filed it, and it got approved. I'm not saying you have to hire a lawyer for everything, but just go through the checklist on the 45, know exactly what you need to give, because if you're doing it piecemeal, they request one thing, you give one thing, they give you another thing, you might have to go through this for like 2-3 years, or worse yet, they just deny you and make you file the whole thing and restart the whole clock, right?
Can you talk a little about the government sent email to lawful immigrants to leave the country right away?
The government has sent inadvertently that email to both U.S. citizens, lawful permanent residents, and visa holders, and also undocumented people. If you are a U.S. citizen and you're a lawful permanent resident, and you got that, double check, triple check, because it is likely that the officers and the USCIS made a mistake. But it is also possible that you might be suffering identity theft, or that you have a hit on your record that you are not aware of, and that causes you to be inadmissible or deportable. So don't presume you are completely safe just because you're a lawful permanent and U.S. citizen, and just because USCIS has been making mistakes with other people. It doesn't mean you are completely safe. So do the precautious thing and double check. Is that really accurate? Is there anything that's on your record? Pull your own criminal record, right? Because the only reason they're deporting you as a U.S. citizen or as a permanent resident is if they can determine that you got your green card, you got your citizenship fraudulently, and so now they're going to revoke that, and you're going to go through court and you're going to fight it out. If you're a F1 visa holder, if you're a tourist, unfortunately, this has been going out to so many people. sue the government on the TRO and the preliminary injunction so you can revert back. That is, after all the analysis that we've done, I think that is the right choice for most people.
Can a court case history stops you from meeting your spouse in the U.S.?
Can a court history stop you from meeting your spouse?
Yeah, in the U.S.
Meaning you are abroad right now, and because you have a criminal record, you cannot fly to the U.S. and meet your spouse? Yes. If you are abroad and you don't have a visa or travel document to enter the U.S., and you have a court history, the consulate, the CBP might not allow you in.
I got green card via VAWA. How long can I wait to file citizenship, especially?
If you're married to a U.S. citizen and you've had a green card for 3 years, you can file for citizenship. If not, you have to have your green card for 5 years, then you can file, provided that you meet all the other requirements of a citizenship application.
I don't understand this question, but at what point do the HOC 2R regulations negate due process?
I don't know either. We'll skip that.
Last update on my I-130, they canceled the RFE but not approved my case.
The question is, the last update on the I-130 application is that they canceled the request for evidence.
Yeah.
But they didn't approve the case yet.
Yeah.
So I guess it's optimistic or pessimistic time. If they're optimistic, they made an error, so they canceled the request for evidence. So they'll approve your case when the time is right. Right, I-130s take a long time to process. Unlike other cases that takes 2 weeks, this could take years. But if you're very pessimistic, then they could give you a new request for evidence or give you a notice of intent to deny or just outrightly deny the case.
Hi, I have a criminal case in using a fake driver license. Does it stop me from getting a visa to join my wife in the U.S.?
If you told that to a CBP officer, they will not let you in the country. And if you told that to a consular officer, they will not let you into the country. If you didn't tell them and they discover it, then they can void your visa. So it is a very tricky and precarious situation that you're in. And the question, again, I just want to repeat it, is that you use a false identification, and will that prevent you from coming to the U.S. to meet your spouse? And so any sort of crime that involves moral turpitude that could be interpreted as such by the CBP officer or by the consular officer could prevent you from getting any appropriate visas.
Okay. We have 2 minutes left.
Okay.
And then he asked, what about for asylum?
I cannot answer any asylum questions, mainly because we don't do asylum here at the office. There are many, many competent attorneys that do asylum. We just unfortunately can't do it.
Okay. Is having a speeding ticket have problem in applying through marriage citizenship?
As of now, no, provided that your speeding ticket is not a manslaughter or heavy negligence, right? Because if you're speeding like 100 miles per hour or 90 miles per hour in certain places and times, right, and a school zone, you're going down 100, that could be considered manslaughter. And that is like serious stuff. But if it's like, you're driving 60 at a 40 mile per hour area and you got a speeding ticket for like $200, that is not gonna bar you from getting your green card by marrying a US citizen. Yet. Why do I say this yet? Because, if you asked me the same question a couple months ago, and it was, if I have a traffic ticket, will that somehow affect my non-immigrant status as an F1 international student? Everyone would have laughed and say, no, it's just a traffic ticket. But now we're seeing across this entire Great Plains of the United States, if you have even traffic violations, your entire visa could be canceled. Thank you guys all for watching. Really appreciate you guys. We'll see you guys again next week. We'll try to do this every Thursday at noon. Take care. Peace.